Did you know that over half of Americans don't have an estate plan in place? That means millions of families are at risk of facing unnecessary legal hurdles, confusion, and financial strain when a loved one passes away. But the good news, estate planning doesn't have to be complicated. Welcome back, I'm Aaron Francois, and welcome to Law Simplified, where we make the law work for your family. Today, we're breaking down the basics of estate planning, what it is, why it matters, and the essential documents that you need to protect your loved ones. So, what exactly is estate planning? Well, estate planning is all about preparing for future tragedies, right? It's about deciding how your assets are going to be managed and distributed, not only when you are no longer here, but what about when you're incapacitated? It's not just for the wealthy. Estate planning is for everyone, no matter how big or small your estate is. Without an estate plan, your family could face long court proceedings, unexpected expenses, and potential disputes not only amongst themselves, but with other creditors. Estate planning helps to ensure that your wishes are honored, it minimizes taxes, and it provides for peace of mind for your loved ones. Now, let's go over the 5 key components of a solid estate plan. First document we're going to talk about is the last will and testament. In a will, it's going to do several things. First, it outlines your wishes of who you want to inherit your stuff. 2, it names a guardian to be in charge of your minor children if you're no longer here. And 3, it names someone that to be in charge of your estate. Here in Arizona, we call that the personal representative of the estate. In other states, it's commonly known as the executor of the estate. Now, without a will in place, the state of Arizona, or whatever state it is that you live in, will decide for you, based on intestacy laws, on who's gonna get your stuff, who's gonna get your children, and who's gonna be in charge of your estate. And oftentimes, whatever that list is, that's usually not going to align with who you would have wanted to be in charge of those items. Next, let's talk about trusts. A trust is nothing more than a fancy contract that helps you to avoid probate. It provides more control over how your assets are going to be distributed, and you can even protect your beneficiaries from their creditors in the future. I like to say it's the only way that you can protect from the grave. Now, there are many types of trusts out there, but the most common one is what we call a revocable living trust. This allows you to maintain control over your assets during your lifetime. You can take assets in and out, you can modify the agreement at any time, and you can revoke the trust at any time. Another critical document is what we call a power of attorney. This document lets you appoint someone to make financial or legal decisions on your behalf if you're unable to do so. Now, without this document, your loved ones may have to go through a costly and time-consuming guardianship or conservatorship process to make these types of decisions for you if you are ever incapacitated. Think car accident and you're in a coma. Same thing can be true if you are elderly and you develop dementia or Alzheimer's. If you don't have this document, your family's going to be stuck in probate court doing guardianship and conservatorship proceedings for you. Now, bear in mind, in most states, these are 2 separate documents, a financial power of attorney and a medical power of attorney. You want both. Now, your estate plan should also include a healthcare directive. Sometimes this is called a living will. This outlines your wishes for end-of-life decisions in case you're ever unable to communicate those decisions. Think, if I'm in a terminal and artificial situation, I do or I do not want artificial means to keep me alive. This document is very important because it keeps your loved ones from having to guess what your wishes are. Finally, don't forget about your beneficiary designations. Accounts like your life insurance, retirement plans, and bank accounts often allow you to name a beneficiary on those accounts. Keeping these designations up to date can help avoid probate and ensure the right people receive your assets. And this works because beneficiary designations travel outside of the probate court process. Now, before we wrap up, let's talk about some common estate planning mistakes that you're gonna want to avoid. First major mistake is simply not updating your estate plan after major life events like marriage, divorce, or having children, or even grandbabies. Second, failing to fund your trust. Just simply having a trust document is not enough to avoid probate court. Your assets need to be properly titled in the name of the trust for them to actually avoid probate. Third, Overlooking digital assets. Think about your online accounts, social media, and cryptocurrency. Do you want your family to have access to those when you pass away? Access to things like Gmail are extremely important because of two-factor authentication these days. But along those same lines, you may not want them to have complete access, right? Many people freak out when you simply hand them their phone because they're worried about how far you're gonna swipe on their photo albums. Think about stuff like that when you're creating your estate plan. Now, estate planning is one of the most important things you can do to protect your loved ones and ensure that your wishes are honored. If you have any questions or you need help getting started, drop them in the comments below. I typically use comments from my videos to make more content down the road. And don't forget to check out our next video on tips to fund your house into a trust, where I'm gonna share practical tips from an attorney on how you can make sure that your real property stays out of probate court after you die.